Hi, my name is Jack Gross. I'm a partner at Gross McGinley working in our business services group. I want to tell you a little today about the Federal Trade Commission's rule regarding non-competition. A Federal Trade Commission was formed over 100 years ago to promote competition in the American economy. Recently, it has also expanded its role to promote consumer protection and also involve itself more deeply in business activities. Last year, the FTC, through research, decided that non-competition clauses that are used today by many, in fact, almost all businesses in America, were having a negative impact on the economy, primarily because they prevent employees from freely moving between jobs. The FTC determined that that restriction was affecting not only the employees who are subject to the non-compete clauses, but all employees because it depressed wages for employees and also limits the availability of positions in the market. Based on all of that finding, the FTC decided dramatically that they were going to implement a nationwide ban on non-competition provisions. This would be an enormous change to the way employment works in America. As I mentioned a minute ago, almost all businesses, particularly larger businesses, but even smaller businesses, local businesses, medical practices, professional businesses of all sorts, use non-competition provisions in their employment agreements. If the FTC succeeds in banning those, it will change the nature of employment in America in a way that really hasn't been seen in over 100 years. What the FTC rule would do, if it is implemented, likely next year, would be to ban non-competition provisions generally. It would also, and I think more dramatically, require employers that use non-competition provisions to notify their employees that they are no longer valid. This affirmative obligation would mean that every employer who has a non-competition provision in any employee contract would have to write to all of their employees who have them and tell them that those provisions are no longer valid. So another very important thing about the requirement that employers notify employees that the non-compete is no longer valid is that it applies not only to current employees, but all former employees who are still in a non-competition period. The only exception to this new proposed rule is in the sale of a business. So if an owner of a business sells their business, it is typical, it is standard, that the sale of the business will include a provision that the seller can't compete against the buyer. The FTC has agreed that those non-competition provisions would still be lawful. At the moment, the rule doesn't extend to non-solicitation provisions or non-disclosure agreements. There has been requests for the rule to extend to those other types of restricted covenants. We'll see. The FTC is still considering this. That would be even more dramatic if those are also included in the final rule. At the moment, the FTC has received over 27,000 comments on the proposed rule. Because of the number of comments they received, they are likely to be working on the rule for the remainder of 2023, and we expect a vote on the rule sometime in 2024. So there is some time. There's really nothing at the moment that businesses can do to prepare for this. I recommend that businesses continue to use non-competition agreements the way they have. At the moment, they are valid, at least valid in Pennsylvania, not in every state, but they remain valid. If the rule is implemented, again, as I mentioned before, it will be dramatic because not only will all of those provisions become invalid, but we will need to notify all employees that that has happened. The FTC's rationale for doing this is that the use of non-compete provisions is unfair competition under the FTC Act. That's the way they're legally going to justify banning a common contractual provision nationwide. One of the main concerns the FTC has is that several states already ban non-competition provisions, but those bans have been difficult to enforce, and many employers haven't notified employees that those provisions are no longer valid. The FTC has used that and their ability to regulate competition to attempt to create a national standard regarding non-competition. We will see if that works. In addition to needing to finish the rulemaking process, the FTC obviously has to vote on the rule, and I fully expect if they adopt the rule, there will be substantial and immediate legal challenge. Employers, businesses need to be prepared. If the rule is adopted next year, there will be a short period of time, likely no more than 6 months, in order for businesses to adjust, react, and take the required steps to notify employees about what has happened. Thank you.